Mr. Cohen.
Thank you, Mr. Chairman. First, I'd like to ask Ms. Murphy a few questions. It's been gone over pretty much, but I'd like to get into the legal distinctions of Griswold and Roe versus Oberfield and Loving. Were two of those cases decided only on substantive due process and the other two both substantial due process and equal protection?
That is correct, Representative Cohen.
So if that's correct, and I thought it was, and I appreciate your clarifying for me, how could one distinguish this case on gay marriage from the case on interracial marriage? Is there any way to distinguish it at all legally?
To my mind, there is no way to distinguish the two. Both of them acknowledge that there is a right to marry or not, and that implicit in that right is the right to marry a person of one's choice.
It was interesting to me when I saw Clarence Thomas not mention Loving, which of course ended what was archaic and abhorrent policy of telling people that you couldn't marry somebody of a different race. It certainly affected Senator McConnell. It certainly affected Justice Thomas, my good friend back in Memphis, the late Judge Sugarman, and so many others. The lady from the minority side, is it Ms. Foster or Ms. Fletcher?
Foster. Mm-hmm.
Thank you, Ms. Foster. You are a constitutional expert, as I understand it. Do you agree that that Loving versus Virginia is indistinguishable from Oberfeld, and if taken up, and Justice Clarence Thomas suggested that it could be and probably would be struck down by this court?
You know, I'm a constitutional attorney specializing in bioethics, not in marriage, but I would point out that in Loving, that decision was based on equal protection with about 2 paragraphs on substantive due process. Obergefell was based on both equal protection and substantive due process woven together in Justice Kennedy's opinion. But I would simply say that that when it comes to those cases, unlike Roe and Casey, we haven't seen a court challenge since those cases, as opposed to Roe and Casey, where we saw a Supreme Court case on abortion on average every 2.5 years or so, ever since those cases came down.
Ms. Foster, thank you. I just do want to say this, that even though there were just 2 paragraphs, they are the same, they're similar. And I would suggest in your expertise, if you specialize in ethics, I think that when the right to marry the person of your choice is at risk, and is only held up by a thin thread between 2 paragraphs and a few more paragraphs, that should include your subject matter of ethics and the law and the court, because there's nothing more unethical than the court and the United States saying you cannot marry the person you want to because of race or because of gender. Ms. Fishbach had a nice argument about the child at 6 weeks and the child at 15 weeks. She sounded much like Justice Roberts, who kind of said the same thing and said we should not repeal Roe v. Wade, but we should uphold the Mississippi law, which was the 15-week ban. But Justice Roberts was outvoted by his 5 more radical members of the court who took the Federalist Society's pledge to go to the court and get rid of Roe v. Wade. And they did their instructions. They were Pavlovian, and they responded, and that has hurt American women. Someone earlier said, and I hate to think this, because I love America. I'm an American and love America and love this country, and I think it's a great country. But they said we're the freest country in the world. I think it was Ms. Foster. Well, right now, Canada's the freest country in the world. And there are a few other countries along with Canada that are more free than America when we cut women away from having the opportunity to get their families and their bodies to be their choices. The whole idea, though, of it being just not outlawed, but going back to the states is a red herring. The fact is, in the hardcore red states of the Southeast, one time known as the Confederacy, there is but 1 or 2 states that would not ban abortion entirely. And those states did not offer many votes for the civil rights laws. They were passed by Congress without many votes from those red states, and even the red states outside of the Confederacy. So we have to be concerned. You know, the idea of the states having power was not because the states were concerned about a oppressive government or because of abortion. It was because of slavery. And slavery was wrong, and outlawing abortion is wrong, and outlawing gay marriage is wrong. I yield back the balance of my time.
Gentleman yields back.